Today, we will learn about the recently passed labour codes in India. After India became independent, it was largely felt that the labour policy must emphasize upon self-reliance on the part of the workers. Since independence till 1954, the period when V.V. Giri was the labour minister, all official pronouncements emphasized that labour should become self-reliant. An equally forceful view had been to prefer reliance upon the government. This cross current of approach to the labour policy gave place to a new approach known as tripartism, paying reliance on three-party approach, namely the trade union representing the workers, the employers, and the government. They meet together, discuss the points in dispute, and strive to reach a consensus. And if they agree, they make recommendations. Out of the three, the role of the government is more important. Annual labour conferences and the permanent standing labour committees served as the chief instruments of tripartism. Labour law in India covers the industrial relations, certification of unions, labour management relations, collective bargaining, and unfair labour practices, and the workplace health and safety with good environmental conditions. It also focuses on conditions of employment, including general holidays, annual leave, working hours, unfair dismissals, minimum wage, layoff procedures, and severance pay, and many other issues related to employer and employee and the various compliance requirements. You may also note that what started as regulation of master-servant relationship in pre-independent India has now grown into a dynamic law that governs the employer-employee state matrix but also recognizes newer trends in employment like gig and platform economy. Recently, a consolidation of 44 labour legislations was done in form of 4 new labour codes. Each code deals with a specific category of issues and perspective of labour law. Let us now talk about the Code on Wages 2019. It was passed to combine legislations regarding payment of wages, bonus, and other claims under one statute to govern matters like fixing of minimum wage, wage period, mode of payment, and ensuring that they are timely paid, etc. It deals in detail as to what constitutes a minimum wage and what types of deductions are allowed under the legislation. The code also fixes the number of hours in a working day and provides for overtime work. The code also deals with payment of bonus and incidental matters like eligibility, permitted deductions and reductions, disqualifications, computation, and timely payment. The code empowers the central government to fix a floor wage and give directions with respect to the matters provided in the code. It also provides for establishment of advisory boards both at central and state level and appointment of inspector cum facilitators. The code also empowers appropriate government to penalize offences committed by an employer with respect to payment of wages. Let us now move on to the Industrial Relations Code 2020. It was passed with an aim to govern matters regarding adjudication of industrial disputes, standing orders, and regulation of trade unions, strikes, retrenchments, and layoffs, etc. The code seeks to establish a works committee, grievance redressal committee, industrial tribunals at state level along with national industrial tribunals for a proper settlement of disputes arising out of employment and incidental issues. The code promotes arbitration and conciliation by providing the parties in dispute with a choice to voluntarily refer to arbitration by appointment of conciliation officers. Chapter 3 of the code also regulates trade unions with respect to matters regarding incorporation, registration including cancellation, recognition, dissolution, etc. Chapter 8 of the code deals with strikes and lockouts. The new code has reduced the notice period required for a strike to 14 days. Chapter 9 and 10 deal with provisions relating to layoffs, retrenchments, as well as closures. The significant variation from previous legislations to this one is the increase in threshold limit to 300 workers or above in an establishment. Another noteworthy development is the Workers' Reskilling Fund to be set up by the appropriate government for the benefit of retrenched workers. The code prohibits unfair labor practices and empowers officials appointed by the appropriate government to penalize defaulters. Let me now introduce you to our next law. In order to simplify and rationalize laws relating to social security provisions like provident fund, pensions, insurance, compensation, etc., extending to workers engaged in the unorganized as well as the organized sector, Code on Social Security 2020 was passed. The first schedule of Social Security Code provides for the establishment on which the code is applicable based on the number of workers employed in them. Every establishment to which the code is applicable needs to be registered mandatorily. Chapter 2 of the Social Security Code provides for establishment and functioning of various social security organizations for proper discharge of welfare and administrative roles such as Board of Trustees of Employees Provident Fund and Employees State Insurance Corporations. Social Security Code authorizes the central government to establish a national social security board for the unorganized workers with a suitable representation of women, minorities, SCs and STs among the board members who shall meet triannually to discuss social schemes. The state government is also empowered to establish an advisory committee to advise and assist on matters regarding construction workers with respect to the code. We finally move on to the last code in this category. For proper regulation of safety, health and other conditions relating to work performed by employees and workers, a consolidated Occupational Safety, Health and Working Conditions Code 2020 was passed. The code authorizes the central government to establish a National Occupational Safety and Health Advisory Board for proper implementation of the code. The central government shall prescribe for the appointment, mode of nomination, terms and conditions of the members, along with rules regarding allowances, including salaries and process of filing vacancies of assisting employees required in the office. It is also empowered to assign more functions to NOSHAB and to establish advisory and technical committees to advise and assist on matters regarding the code. This code also authorizes state governments to establish State Occupational Safety and Health Advisory Board for the same purpose as above, as at state levels to establish an advisory committee to advise and assist on matters regarding the administration of the code. The code enumerates the role and functions that the board may undertake towards standardization and implementation of safety and other health measures to be ensured under the code. It also directs institutions working in the field of occupational health to carry out R&D in the area to be submitted to appropriate government in form of recommendations and empowers officials under the code to conduct surveys in establishments to assess compliance with occupational safety and health standards. It also directs appropriate governments to timely collect statistics and data with respect to interstate migrant workers. This code also provides for establishment of safety committee in any establishment as directed by the appropriate government and appointment of safety officers in establishments where at least 250 construction workers are employed. It also deals with penalizing provisions in cases of violations. It also provides for establishment of Social Security Fund for the benefit of workers engaged in the unorganized sector sourcing funds from penalties imposed on the employers under the code or sources as the government deems fit. Thank you. I hope you learned something new today.